following program on Other Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss entertainment law in Sri Lanka. What legislature govern the creation of content and how is the landscape of entertainment expected to change in the future? A very good evening and thank you for taking the time to join us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Now today's topic is a very interesting one that impacts all of us watching tonight, and that's on entertainment law. Of course, we indulge in content for entertainment, but we really never know about the legal processes that go on behind the scenes in order to make these contents actually a success on television or other media. And to speak about this, we have someone that's very well suited for this topic, and that is Mr. Chanakya Jayadeva, attorney at law. So thank you very much for actually taking the time to visit our studio and explain to our viewers about this intricate topic.
Thank you, Anuradhi, and thank you for inviting me for this program. It's nice to be here.
Thank you. A little bit of an overview on how we're actually going to be approaching this topic. First, we're going to be talking about the basics of entertainment law, what exactly the legislature entails. Next, we'll be talking about specifics and also on contracts as well. And finally, we'll be talking about the future of entertainment law in Sri Lanka.
My name is Derana and I am a private tuition teacher. My question is on the basics, what legislature governs the entertainment sphere?
Alright, well, without any further ado, let's get right into the nitty-gritties of this topic. So once again, thank you very much. We have quite a bit to cover and unfortunately very little time. So I think I should start off where it matters most to our viewers to understand, and that's on the basics. Could you please give us a proper overview, a brief overview of entertainment law and its context and relevance when it comes to Sri Lanka?
Yeah, actually I must tell you, Anurad, this is a growing area of law in Sri Lanka and as well as the rest of the Asia, although Asia has the biggest market on entertainment products being made, that is Bollywood. Sri Lanka does not come close, but laws-wise they are a little bit behind, but it's a growing area of law. Now, when you say entertainment law, it covers laws that deals with if you make a music product, entertainment product of music, which is a song or a performance on a song. And also it covers the film industry, everything to do with the film industry and the music industry, I must say. And also the television, this industry. And then it spills over even to the older generation of entertainment law. If you can remember, in our small days we used to read books, but our parents or grandparents' generation, there was no television, radio, and then it was books. So literary publishing. These four major areas are covered under entertainment law. That means things that happen in these productions or things that take place in distributing entertainment products, what laws that deals with is what entertainment law discusses.
Right. So entertainment law does not just revolve around the more popular forms of medium like film and movies, but also touches on multiple areas like music and also text, literary works like books. I think it's important for us to get into one of the key aspects that we believe is entangled when it comes to entertainment law, and that's on intellectual property.
Yeah.
If you could, sir, give us a little bit of an understanding on how intellectual property laws actually weigh in when it comes to the protection of artists and creators in the field of entertainment.
Correct, you're very correct. If I may say this, there are three pillars that stands behind entertainment law. One is intellectual property, and especially the branch of copyright on entertainment law on intellectual property. Then the labor laws, because there are lots of contracts, service contracts of when you're hiring talent. Now you are a talent hired by this institution as a presenter, so it's a talent hiring. So the labor contract, and then also the other area of law that kicks in for entertainment law is law of contracts and agreements, right? For talent hiring, you need contract. So these three areas has to be mastered. Anybody who wants to do with entertainment law. To answer your question with regard to the intellectual property law's involvement in entertainment law, 90% or 80%, I must say, what dabbles in a day-to-day life on entertainment production, or that means either a song or a television program or a film or a book publishing, it's the copyright branch of the intellectual property law. Now, copyright, as if I may take time to explain a little bit of copyright for the understanding of our viewers, copyright, a lot of people think how you get your copyright. Now, there are big authors as well as the Berne Convention, which Sri Lanka is a signatory to, and the international conventions that deals with copyright and intellectual property has, and judgments from superior courts across the globe has reiterated time and time again that the copyright of something is there for you the moment you create it, and as long as the creation is original and an independent, authentic work. Right? Now that's I'm summing up a whole heap of things in those few words. So copyright, for you to get copyright on anything you do, you don't need to get it registered anywhere. But there's optional registration. We can talk as we go forward. Once you have the copyright of whatever you write. Now I wrote some notes for this. Even this note I wrote for this program, I have copyright on that. So the freedom person who owns the copyright has is contractual, remuneration and enforcement. There's three areas. Contractual means you can, whatever you have written, either a book or a lyrics of a song or a composition of a music or a film script or a film or a concept of a television program or anything, you can contract it out in our act also. We have an act number 16 of 2003. Our act also provides under section 16. We allow people to assign it or license it to a third party. Right, in any of these areas. Then remuneration means when you license it, you have to get a remuneration for whatever you license, right? You can't, unless you want to forego that, that's your right. And then in the event of a violation of a copyright, you have the right under copyright law worldwide to enforce violation. So we can go into all details of how this happens, subject specific to music and films and literary publishing on different areas, so that the listeners or viewers will have better understanding.
Exactly, and I think it's the perfect segue for us to actually get into the specifics now. Of course, talking about entertainment law in a general sense, of course there is only so much understanding that we can get when it's not an umbrella law. We have multiple varying types of entertainment, and therefore we have multiple varying types of application of the law when it comes to these types of entertainment. So I think we should start with what I believe would be one of the most common areas that we have all interacted with, and that's on music and record labels. If you could, sir, explain to us, now that we have a basic understanding of copyright, the legal challenges, the key legal challenges that can be faced by musicians and also record labels when it comes to the protection of content.
Yeah, now when you take the issues come with regard to music, this is very good that you asked me, because if you look at Sri Lanka, although remember I told you the law is still developing, but issues I see mainly in Sri Lankan entertainment law comes up with regard to music and songs and performance, right? Now, first of all, for the understanding, a lot of people don't know who owns the rights for a song, right? How you own a right and how it will boil down in the interpretation in courts or with regard to the law. So when you take a song has several different rights. We have a thing called element rights, and then the final works product right, that is the song, the produced song. Elements means song has two elements, that is lyrics and the composition of music. Composition can be broken down to several other areas, because when you look at the music music per se, the science of music, you find that there is a vocal melody and there are other melodies which makes the composition. But be that as it may, there's a thing called composition, and composition has its independent right. The right is there for the person who composed, right? Like I said, he composed it, and if you can prove he composed it, it's his or her right. Same with the lyrics. Now a person who writes the lyrics has the rights for the lyrics. Now you put these two together and you get somebody to sing and you make a song. Now when you make a song, you have to, in our law as well as other law, we recognize it as a sound recording. The sound recording, or that's the audio version of the song. If you put visuals to that and make a video production, then it goes as an audio visual work, which is a separate thing. Now, the sound recording's ownership can be of a different person, right? Now here's the thing, a lot of people are confused who will own. Now I'll explain this graphically by way of an example. We say three people get together, one person writes the lyrics, one person writes a composition, and one person sings. Now say there's a singer, and then a third party comes in and puts the money. Generally production of a sound recording is money, to produce a song to a CD or digital form and distribute, etc., etc. So when you the third party, all these four parties get together. So the sound recording version, the final version of the song is who owns that? That will be owned by the person who produces that. Now, can he just own that like that? No, because I remember I told you and I'm explaining copyright, there are contractual freedom to people who owns copyright. So he will have to buy the sound recording, the elements of the song, that is the composition and the lyrics from those people. Now, when they give the elements to the sound recording, they can either completely assign it forever with all the types of right. I'll explain what are all the types of right, or they can just give a limited purpose one. Now what's a limited purpose one? They will say, okay, I'm giving you for this version, right? I'm giving you the pop version of this song, both together, and that's all. I'm not giving you concert rights, I'm not giving you video production rights, I'm not giving you rights worldwide, I'm only giving you for Sri Lanka, and I'm not giving you adaptation rights. That's thing called adaptation. That means you can translate that to another language or a theatrical, and I'm not giving you theatrical rights. That means you can't put it on a film. I'm not giving you, you can, if somebody has 12 songs or some songs, you can make a musical out of it. I'm not giving you theater production right, nothing. Only one song you can produce, and that is what I'm giving you here. So they can do that. Or else, everything I told you I'm not giving you, he or she can give all that also to the producer, right? And then the producer takes these things, and then they put a musician, or who's called a performer in our law as well as worldwide. Performer sings the song, right? Now, one of the misconceptions which I had to clear in Sri Lanka, the performers think they have copyright. Some countries also, they think like that. Now, remember, the copyright is there for the product of the song to the producer if he has properly secured from the composer and lyrics writer by way of contract under Section 16 of the Intellectual Property Act. Now, performer, what does he get? He doesn't get a copyright. He only performs a song which somebody has written the lyrics, somebody has given music, and he performs it, he brings it live, right? He makes the song alive, and then he gets a right called performance remuneration right. Now, I remember I told you about copyright remuneration. That is not the remuneration. It's a different kind of remuneration which is recognized under our Act. So he can, it all depends on the bargaining power. Now, if he's a fledgling artist, they can say, okay, I'll come and perform this song. I want this much of, as much as you sell the records or a digital or whatever, Spotify or whatever way you are going to sell it. I want each sale this much of money, and I want initial money of this much. And when it's broadcasted on radio and TV, I want money from that as well, all that. So depending on his contract with the producer. Or else he can just agree, if he's a young artist who's coming up, they will generally agree for something to be given initially, and that's all. And then there's subsequently, of course, when you broadcast, you have to get a remuneration from television and radio channels. So that is the only right he gets. And the other right the performer gets is authorize his performance to broadcast once. Now, if a performer comes and sings a song here, before he comes, we enter into contracts, and they can authorize to be broadcast or not, right? Obviously, when you come to television station, you're authorizing broadcasting. But if you go to a stage or something, if somebody is recording that, he can say, look here, I'm only performing for this audience here. You can't record my things and broadcast. That is why you would have seen, Anuradhi, international artists come to Sri Lanka, there's no television cameras there.
Exactly.
You can't. Right? Sometimes I know they have a conference in Sri Lanka where they took rights to record the whole thing, broadcast years later when the value is gone, right? This is all business. So that's why. So the performer has a right to authorize. Now I told you about 3-4 parties. No, the 3-4 parties and the producer. Now these all can be one person also. Now if you take an artist like Lionel Richie or Michael Jackson, probably not your generation, or you'll take even Beyonce or even Taylor Swift. So there are people in those countries. They write the lyrics. They write, they compose the music, they are qualified, and they have money to produce the song, and they sing also. So who owns it? They don't have to put contracts among themselves. They draft it in such a way that in case of a proof, there is proof. It's all theirs. So all the remuneration from wherever they sell, they collect it.
Exactly.
Yeah.
So
Yeah.
that itself explains that while it can be broken into multiple segments where a few tens of people can actually hold certain valuable aspects of a contract, one individual can also produce their own piece of music.
That's correct.
And have all copyright.
Yes.
But that's not usually the case. I believe that would be important for the viewers to understand
That's
that
not usually
just
the
because the
case.
performer is performing a song doesn't mean they have entirety copyright for that song and for that piece of music.
Yeah.
Before we go in for a break, sir, could you please quickly explain to us any key areas that you have seen being in the field, common types of copyright infringement that you have seen specifically in the field of music?
Yeah, if you in music, copyright violation mostly happens when somebody does a similar song, the other party who did the old song, which sounds alike, thinks this is copied from their song. Now the classic example case is Ed Sheeran's case. You would have heard about that. Ed Sheeran had a song called Thinking Out Loud, and then Marvin Gaye's daughter sued him, saying Marvin Gaye, her father, because she was an heir to the estate of the father, and the song, as you know, copyright lasts life plus 70 years, so Marvin Gaye is dead, but his daughter has the rights for 70 more years. It was copied, the composition was copied from Marvin Gaye's song called Let's Get It On, right? But they went into the matter in New York. They went into a trial, and this is one of the latest cases I'm saying, and they said this is not so. It may sound alike. It may sound alike because nobody can own the building blocks of like A, B, C, D. Nobody can own the building blocks of music. That is do, re, mi, fa, sol, la, ti. Those music notations. So if somebody says that look, this person copied it this way, there are a lot of nitty-gritty details. We have no time to go into that. But just because something sounds alike, it doesn't mean it has been copied. Because nobody can own. The presentation style, everything has to be different, right? Now, in this song, Marvin Gaye's song, they found similarities in things like chord progression, rhythm, everything was similar. But the court held it is not so, because it can sound alike to an ear, but when you put on the notations, when you put on and analyze the whole thing, it is not the case. Because if such things were to be allowed, creation will stop. Because the music, like I will tell you about the literary publishing also later, music, Anuradhi, like everything else, yes, it is, you are inspired and influenced from previous work. Otherwise, you can't do it. So is writing. That's why writers read, the person who has read most become the best writer. Invariably, it comes on a different way when you write. So that cannot be stopped. That's why the courts have several times held in judgments, especially in advanced countries like US and Europe, that one line they have said, copyright protection is not only to protect your work, it cannot stand to stifle other people's creation, being inspired by this work. Exactly. So that's what I say. So I can't go, since lack of time, I can't go into breaking down the case, but it's an interesting case.
Exactly. I think the key point to pick up from there is copyright is not intended to stifle creativity, but rather to protect it and foster it. I believe we have to speak about the specifics now. We just touched on the bare surface of music, but we have to talk about film and TV productions as well as literary works as well, which I believe is much more vaster in comparison with its time of existence as well. But before we get into any of those specifics, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back.
And I'm a physiotherapy student at International Institute of Health Science. So my question is on specific. How are contracts significant to the protection of artists and content?
Welcome back to Law, Land and Liberty. We're in discussion with Mr. Chanakya, Jayadeva, attorney at law. We were speaking about the specifics and the intricacies of entertainment law. We just got done with the basics and we got to touch very briefly on music and the legal specifics entailed when it comes to copyright and music as well. And of course, we have to get into, I believe, one of the most relevant, I believe it would be the most interesting for our viewers to understand as well when it comes to entertainment, specifically films and TV productions. If you could explain to us the legal processes when it comes to actually producing and distributing films and other related content, visual media in Sri Lanka.
Now, whether it's a television program, a TV serial, or whether it's a film, or it's the same. It's what you call filmed entertainment, right? Now, one of the things, it's good that you touch upon the contractual part as you introduce this, is that not worldwide, I'll say Asia-wide, people get into problems because the contracts are not in properly placed when it comes to film. Film industry largely deal with, starts from what we call script to screen, starts from an idea which is started as a story. So the story develops up to the screen. Up to the screen, there's so many things happening: pre-production, pre-development, pre-production, production, post-production, distribution, etc., like you mentioned. So this whole process has to go through what you call a set of contracts. Now, in the international arena, they have a necessity, and they call it the COT, the chain of title agreements, right, in a film. Now, for somebody to even come as funding to get the film, or if somebody to come and buy the distribution, we'll say Lionsgate to buy a film that you made, they will not buy it if they are not satisfied with the totality of COT contracts. That's chain of title contracts. Now, when you say chain of titles, you can also think about a land issue, where if you buy a house, we do a land registry research, and we see how many, from the very first time the land owner, at least 35 to 40 years, we check whether the title is clear. So it's as simple as that. It's not simple because the type of contracts are different here. It doesn't need to be registered. A lot of people misunderstand that contracts need to be registered. It's not. So what are the types of contracts that go into COT is the most important thing for people to know if you are doing any kind of a filmed entertainment. So, like I said earlier, there are screenplay. The script is there, right? So script, if somebody has written, if the person brings it to me or you, will say the producer person, he wants to produce, then what that person has to look into is how is he giving the script to you. That is, whether there are, you have to see two major things, whether there are underlying works. Underlying works means whether he can get influence and inspired, like I told before the break about writers getting inspired and influence, but whether he has copied chunks from other people's work, whether it's here or any part of the work, right? If so, he has to prove clear that he has cleared those copies, incorporations into this script. And then second thing, there are so many other areas. Second main thing he has to check before taking the script to a production is that what kind of a rights he give. Now see, a person I can have a story and I can give it to Derana to do a film, right? And I will tell you, I'll give you the script to do only a television series. Then I will retain theatrical release a different feature film rights. Documentary rights I'll retain. Then making a play out of it, I will retain. Musical I will retain. So many rights you can retain. Then publishing it as a book I can retain, right? So whether all those are given or not is what you have to check on the screenwriter's contract. It has to be incorporated. And why I said about the underlying works very important, sometimes people write things out of books. They write gets inspired complete book, they convert it to a screenplay. You can't just convert like that without the authority of the person who wrote the book. So all that, you have to check whether those pre-existing agreements are there, plus giving an indemnification or a guarantee that such things have been cleared in the script. And after the script, when you go into hiring a talent, we call it talent in the entertainment industry, which is actors, directors, even special stunts and editors, all these people, these are talent hiring agreements also you have to properly put in, because sometimes the talent fledgling artists have different issues they bring about. Now I know for a fact there's a film in somewhere in 2000, Sharon Stone who acted, she said she was a big artist by then, she has become popular, she said no, her face can't be used for publicizing in posters, etc. So then some company somewhere across the globe violated that and put her face to get it more publicized. Then she took legal action. So that's kind of a thing you have to be very careful when you are getting fledgling artists, what kind of rights they are signing into. There's so many details you have to go into, which I have no time to go in. And then director also. Whether, now there's a big thing called clash between the director and the production company. Right now, this institution also, or any person can retain a director to do a film. Then the director will want director's version. So there's a thing called final cut in the film. Whether the final cut is director's version or what the corporation wants, all that has to be one of the main things that are incorporated in the agreement. Now, if it's a fledgling director who has proven track record, bankable director, where whatever he does becomes hit like Steven Spielberg or somebody like that, James Cameron or somebody, then the production companies don't bother about that. They say, okay, you have your version, we know you will deliver, right? You will not make it a loss. Other directors, that issue comes. Same with stunts. Then there are insurance matters coming in with big artists. A lot of people don't look into that. Yesterday I was getting ready for this to an insurance company friend of mine. I asked whether you have type of insurance, which I'll mention later. Those sort of insurance are not even heard of in Asia. That means in talent agreements, if we say you're hiring Julia Roberts or Tom Cruise or Shah Rukh Khan or some artist, even Jacqueline, a big artist like that, they have personal insurance. They will not allow certain acts to be done thinking it will damage that person, right? Is therefore voice also in music industry in other countries. So you have to look into those insurance contracts they have and sync with the talent hiring agreements with that. And then there are other agreements you have to put into. Everything has to be agreement. That's why chain of title I'm telling you. I'm going to the chain of title thing. That is, we call it now, earlier one was called ATL, above the line. The other one is called BTL, that is other creators like technical crew and all those other people who supply food, drinks and everything, production, transport, those things also you have to enter into. And then locations and everything you have to put into. Then the other major area in a film, Anuradhi, is that there's a film music track, no? Same rules of the song, if there's a song incorporated, applies here, which I told before the break. And then in addition to that, there's a soundtrack, music sound score we call it. The sound score creation has to be, under our law, if you create it for commission, that means if I pay you to create music or anything, and if I can prove that I paid it to do it to incorporate on this film, then you have done it for me. But it is not as that straightforward and simple. Now, I might pay you and you are a musician, you will do the soundtrack for my film and I incorporate. Now, if the absence of agreement, you might say, I did for films, but I did not only gave it for you for films. I will keep different versions. If you are a fledgling musician, music creator, you can say, okay, I'm going to create this, but I'm going to do songs and I'm going to release these as instrumental versions or whatever versions to another company for audio, as audio productions or theatrical or whatever. I'm retaining those rights, they can say. So, but producers generally don't agree for that. They take the bulk of the right because they are paying to be done exclusively on the soundtrack of all this thing. But soundtrack has, even right now, there are issues in certain films where they have had no contracts and the person has released a soundtrack songs independently and created issues. So it's better to have a contract there as well, although the law allows you. Then other area films get into problem is now you come and shoot in anywhere. Now, if you shoot in some place where there's backdrop, even to a vase or something like that, right? Trademark products, properties, before buildings, and those things, the copyright has to be cleared by the persons who own those things. Now there are cases where, if I may borrow 1 minute, I have to explain this, where they have incorporated in a Hindi film a ringtone, a phone was ringing and it went for about 30 seconds or something, and then the ringtone company sued the production company because that ringtone was not released to be incorporated in a film. It was given only for that song, only for that phone user. So that has not been cleared. And then there were American films where there were fledgling designers who design vases and all. That's why I explain vase. In the art director has not cleared those things. So the vases were there. They were featured in a film. The person who designed sued saying, I just sold this vase to a company to build from out of clay, but not to be kept in a film because film is making money, no? So then I have to be paid for that. So, and also incorporation of video clips and stills. You can't incorporate video scripts and still there's a thing called stock footage and stock still photos people buy. Of course, if you buy them, it's fine. Otherwise, you can't just incorporate stuff there. So, and then there's also other area in the film, character licensing. You might be surprised to know that when there's character licensing means, now there are comics and all that, there are, out of those comic cartoons and all that, there are particular characters built. If somebody's taking comic book and making a film out of it, those characters may be licensed to people who co-authored that cartoon, where somebody did the whole story and then third party will say, I did the whole story on a cartoon which built up to a children's cartoon and which has become very popular, and you also incorporate, but you were only involved in that particular character, right? You only designed that. So, but then I can't go ahead and sell that rights without paying you and taking your permission, because character has a separate right to be in there. Without that character, that film is nothing. Storyline is one thing, right? And then comes this right to privacy and publicity, which we need to discuss lengthy another time, but it also applies in a way to films. Now, documentary films, I'll tell you something else, but that is especially if you are talking of somebody's life story being featured. It's called depiction release, right? If you are featuring life story of some artist or any person, that person or person's surviving family has the right to release that, or his children or his wife or somebody, they can, unless it's a public document. We'll say there was a case with regard to that person and the case went on to court and it becomes a public document. So if you're only relating to that case, because the court documents under Intellectual Property Act, nobody has copyright, you can use that as long as you don't manipulate that to a wrong interpretation. Then that's fine. But if you are just featuring a life story of a person, you have to get a depiction release from that person to write that life story. Otherwise you can, I know several writers about a particular thing I cannot mention, about, it's not a big artist or anything, he did a big thing for, in Sri Lanka and became very popular. And then without that person is not given the life rights. So those things come up. And of course, public figures, there's an exception. And also Sri Lanka, I don't know whether we have, to my knowledge we don't. In the United States, you have these guilds, like Writers Guild, Directors Guild, Screen Actors Guild, all that, as you can remember, it went on strike last year. Most artists are connected to those guilds. So you can't just independently sometimes sign with those artists without checking the guild contract they have. Because guilds have put a lot of like minimum payment, minimum hours of work, minimum facilities you should have, etc., etc. They put it on there. And then, then comes, do we have time?
Yes, we do.
Right. You have a question? No.
I do have some questions, but I believe this would be better suited for the final segment, and that is on the literary aspects as well. But there are a lot more to cover.
I understand. Yeah. Then now I was telling you all these are coming under COT, chain of titles for a film, Anuradhi. Now there's a thing called E&O insurance. Now however much we put this, we'll say, remember when I was talking about in the beginning of EOT, which starts with a script, no? However much you check what is the underlying work, whether he has cleared that, whether he has not incorporated wrongful things, and whether you have cleared the video clips, audio clips, trademarks, all those things, depiction, release, everything, songs. However much we do that, there can be errors and omissions, right? So internationally there's a thing called error and omission insurance. Yesterday, like I was telling earlier, I checked with the insurance people here. We don't even know that. India also doesn't even know that. So generally we come into after the script is done and after all those agreements are done internationally, they get an insurance company. It's like a title insurance in a unsecured property. You get into an error and insurance. Of course, premiums are very high package. So then only you go for production, right? Because up to all this clearance plus the, if you have all this clearance plus the error and omission insurance only, a serious financier, the production has to be financed. Now we can finalize all these things and get the error and insurance also. And a serious financier will come only if all these chain of title documents, that's why I said this is important, are cleared. And error and omission insurance is specialized insurance products in Europe and America and most countries. They will only approve and give the insurance coverage if all these are in line to the best of their satisfaction. Then once we have that, a producer will come, producer means a financier will come and finance the product and go ahead. Now, once you have all this, we'll say somebody who has money, I have to tell this part also. You don't need a producer, you don't need a financer. You get all this clearance, you put the airline insurance also, and you put your money. Then why, somebody will ask, then why do I need all these agreements so detailedly done? That is because, now if you are the distributor, unless you are the distributor yourself, which most 90% of people are not, the distributor will want to check all this, including the insurance, although you may have put your own money, because they don't want to say a risk, because remember, once the production is done, post-production is finished, it is a distributor who takes the risk, take it and put it either to Netflix and all those streaming movies, or with a theatrical release, or with a television feature film, because it is at that point it comes in touch with the public. And when it comes in touch with the public only, if there's some kind of a copyright or some other violation, it will come to light and they'll get sued. They also will get sued, producer will get sued, but they also will get entangled in the whole business. So they don't want to take that risk, and because of that, they will check on that.
There's a lot of safety nets involved.
Safety nets involved. One last thing I would like to say before we finish this area is that a lot of people have misunderstanding whether titles, film titles, television program titles, radio program titles, even book titles, whether the titles have, Sri Lanka had a big case of that, and it was justified, it is not. There is no copyright on title. Worldwide is accepted. Even Sri Lankan, by a Supreme Court judgment in 2003, it was given. But if you have put that title as a trademark under the category of entertainment, then you can protect that title. As a copyright, you can. Now, you would have heard how many films were made as Titanic before the main Titanic came. There are so many films made. But that particular Titanic version, if he has a trademark, he will have it, and trademark will do every country separately. Otherwise, as a general rule, there is no title on, copyright on title.
Unfortunately, I will have to cut you short in this discussion specifically, so we do have to get into the literary aspects as well. It just goes to show that this entire area is not able to be covered in such a short amount of time, and there are lots of specifics when it comes to the different mediums that we choose to interact with when it comes to entertainment. Before we get into any of the areas relating to litigation from the literary point of view, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back with the final segment.
My name is Dhanuji Veeragon and I am a grade 10 student. My question is on literary content. How does the process of protecting written works differ from visual and audio media?
Welcome back to Law, Land and Liberty. We're in conversation with Mr. Chanakya Jayadeva, attorney at law. Sir, unfortunately, we had to cut you short in the previous segment, and it just goes to show, again, there is a lot more for us to cover. Unfortunately, we do not have as much time in the final segment as we would have liked to have, but it is a very important area that we haven't been able to touch on throughout this entire discussion, and that's on the literary aspects. Now, in one form or another, everyone would have interacted with forms of fiction or non-fiction books and literary works. How exactly does the law play into the protection of these types of contents?
Yeah, Anurag, this is very important and very good that you asked me about the literary publishing thing, because this is something we tend to forget in entertainment industry. We forget that originally we were entertained, maybe our great-great-grandfathers, Shakespeare's time, even before. It's only through books. Books came into becoming plays. Right? Theatre and books went hand in hand. Still it is. Still there are people who read books. I read books, novels, etc., etc. So how does this work? Books also, remember I told you about the script of a film is just like that. It stops there. That's the only difference. It stops at writing, and then you take it to a publisher, and the publisher will have a publishing contract. Before that, just like the chain of title, publisher will do some vetting and get some clearance and get some assurance from you in the contract to show that you have not, there are no underlying works incorporated. If there are, you have taken, if that person say, no, there are underlying work, I have copied this, then they will have to, publisher will not take it unless you show that there is clearance on that, right? And then if there's clearance, and there will be no problem. And otherwise, he will have to give assurance that there's no such underlying work, because at the end of the day, otherwise the publisher also gets sued. So the same thing as script. It's a storyline, it's a story. It goes into the publisher, and publisher publishes it as a book, and then it becomes published. These days, there are multiple publishing rights. You can give the hard text like this publishing rights. As you know, I wrote 2 books. We only had that was on law. That is, we only had hard text publishing rights. Then there are adaptation rights. That means you can keep it to translation version to yourself, and e-book to yourself, audio book to yourself, or you can give all that to the publisher if the publisher is a multifaceted company which supplies author. There are publishers like that in US and other companies where they, in fact, good books, these are not for law books and things like that, but these are for novels. Those books, they take the e-copy right as well, and then they get an audio book right, sometimes old audio books also, and they get a fledgling artist, you won't believe, fledgling artist to read that. Because it's beautiful saying that this audiobook is read by some artist who's a voiceover or actor sometimes, right? So it goes to that level. So those are the literary publishing rights you have. There's a lot of interconnected matters between those things, because if you're the audiobooks right is different, right? It can be a separate contract. Ebook can be separate. Then hard copy can be separate, all three can be, like I said, together. But what you have to understand with regard to book publishing is that there was an example, even though I may not want to mention, I think we can even mention that there was an example that Sri Lanka won the Booker Prize recently. I'm lost to the name of the person who won it, and then there was another person saying that it was his book that was copied. Now, I don't want to go into the nitty-gritties of that, because I don't know what kind of a stage that is in litigation, but as a general rule, I must say, if somebody alleges that I publish a book, you published a book, and if I come and allege you and saying, listen, you have taken my story, it's plagiarism. Plagiarism in the technical interpretation it goes like this. Plagiarism arises when someone tries to pass off another person's idea or work as their own. It can be. So that's not the important part of plagiarism and copyright. Just like you would have heard, every human right is not a fundamental right in Sri Lanka and most countries. Plagiarism, it may be, if I say, go back to the same example and say that, yeah, the book you wrote is my idea and my thoughts, and you have plagiarized, yes, it may be plagiarized, but it is not enforceable. Plagiarism is not enforceable. Only the copyright part of the plagiarism is enforceable. Now, if I say, and if I can prove it on the same example, listen, what you wrote is what I wrote beginning, then you say, okay, prove it. Then I show access. I have to show access. You had access to my work, right? And then I have to show the way I have expressed. You have expressed the same way. Then there's substantial copying. Then there's a copyright violation. But when it comes to stories, especially when it comes to literary publishing, we are talking largely about novels. When you are saying about plagiarism or copying somebody's idea, it cannot. I can't say you copied my storyline, a plot or something, right? Plot is something that cannot be said to have been copied because it's a skeleton of the idea. You can write taking the same plot on a different way. And that is something like, novel.
That's how certain genres exist as well.
Yeah, different genres. I cannot get into. When I say places, I have to show that the character development of yours is same as I have done. The sequence is the same. The timing is the same, and everything in between has been the same. It's like somebody gets up in the morning, gets dressed, go to work, and then during finish work and come home. That could be the plot. You might write about a lawyer doing that. I might write about a doctor doing that. It's all internally different. Character development and sequence and the timing and things they did was different. So therefore you cannot say it has been copied if that kind of a thing comes up. That's the shortest way I can put on the literary publishing. Any question?
Exactly.
Yeah.
When it comes to literary publishing specifically, sir, we also have to look at the actual publishing aspect and getting serial numbers, ISBN numbers in relation. Could you please walk us through the specifics when it comes to that, not just in Sri Lanka, but globally, of course, as ISBN is something that is, relevant to the rest of the world as well. Where exactly do the specifics lie when it comes to serializing a book?
Serializing When you say serializing means not
number,
sequence.
not the sequence of the events or the story progression, of course, but when it comes to actually registering a book.
Yeah. Now, I remember I told you copyright need not be registered in the world. There's no necessity under Berne Convention and other laws. We also don't have registration regime. Now, but if you look at countries like United States and India, where the biggest countries that produce the biggest amount of entertainment properties, as we call it, which includes books as well, they have copyright registration regime, right? One of the ways to answer your question is two-pronged. Yes, ISBN stands, even in Sri Lanka, as a proof, international book standard number, that publishers accepted it, after going through that rigorous process I told you, whether it's an authentic work and the book is yours. On your name. But if you have a copyright registration regime, the writer, what they can do is they can go and register there, in addition to the ISBN number, register the book as a script or a book or whatever, and get a copyright registration thing. But remember this, somebody who has copied after copying your idea, I can go and register in copyright registration, because there's no mechanism in India or America or anywhere to check the whole world's works to see whether I have copied from you or not. So then what is the meaning of registration of copyright? Meaning is very, I must say, it does stand as a deterrent effect for people. Everybody doesn't know the law to this extent, as a deterrent effect for people not to copy. But put it on simple terms, copyright registration is only what you call a date stamp. Date stamp means the day you register it onwards, you can be said to have registered your copyright. But it does not prove authenticity. It's the date stamp, but not prove authenticity. If I may to explain that, I take your book, copy it, write it on a little bit of a different way, copy it. When people copy, they change a little bit here and there, and then I go and get we'll say Sri Lanka has a registration regime, I go and get a registration in Sri Lanka. Or we'll say I go to US or India and get a registration. And then you find this out, and then I say, no, I registered it before you, and I own it, blah, blah, blah. And then you go to court, and you show that I had access, all the proof the points you need to prove in court, you prove all those points and say, look, authentic work was mine, his work is not independent creation, his work is not authentic work, he has copied. So then I lose the case, and I'll be, the person who registered it will be liable for copyright infringement. So that's it. ISBN is a good proof. Copyright registration, if we have, it's okay. It stands as a deterrent, but it's not a foolproof mechanism to protect copyright.
Right, exactly. And unfortunately, along with that question as well, our time has run out with you here today. We did have quite a lot more to touch on, specifically when it comes to the future of entertainment and the protection of entertainment in the coming years as well. Safe to say we will have to visit again back on this topic to actually discuss the specifics in relation to entertainment and also get into the depths of the current context as well. Thank you very much, sir, for taking the time to actually explain to our viewers about this very vast topic in a very brief period of time.
Thank you very much for inviting me. My pleasure. Thank you.
All right, well, as citizens of Sri Lanka who consume content and directly interact with the fields of entertainment on a daily basis, it's important to remain vigilant of the changes in these fields and how it impacts us individually. We leave you tonight with the words of Member of European Parliament Andreas Ansip. The way people enjoy culture and entertainment has completely changed, and this is good. But it is important that we don't leave creators in the cold. That's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/otherderana English. Thank you very much for watching. Have a good night.